right, well, thank you for that introduction. Good evening, everyone. Appreciate you all joining. Appreciate the ISSA for hosting this. See lots of names, some familiar, some not, some I haven't spoken or seen you in years. So thanks for joining. I hope you enjoyed the presentation. I don't know if I have any bizarre hobbies to share with you, unfortunately. I occasionally fly model helicopters. You can see that one behind me. I like to read and do lots of other boring stuff. So hopefully my presentation is more interesting than my hobbies. I will see if we can share this and hopefully everyone can see it. And I'm hoping you're looking at the slide view and not the presenter view. So what everyone sees?
Yeah, looks good.
All right, so that's the first hurdle out of the way. As far as professional background, so I'm a consultant, a licensed attorney in California. I have since about 2015 really focused on privacy, compliance, regulatory compliance, starting with GDPR, and then CCPA and all the others that have come with it. And now I've been working with HIPAA and everything else. Before that, I did security. Was part of the security team and the internal audit team at Symantec, and obviously some other Symantec alumni here. So hopefully they didn't mind my internal auditing too much. And I've been doing privacy and security and similar stuff, I guess about 20 years now. So I've hopefully learned a few things that I can pass along tonight. And of course, this presentation is a risk-based approach to privacy, and hopefully everything you do professionally and and to some extent in your personal lives is risk-based. I always recommend that approach to things, the analytical approach. And specifically, we'll be talking about ISO27701, the PIMS, as an approach to privacy, and I'll talk about what that is and what it isn't, and how you might be able to use that as sort of a framework. Well, I won't say framework because officially ISO uses a different standard as their privacy framework, but as a structure, at least, for building out a privacy program, especially if you're already implementing or considering implementing ISO 27001, which is, of course, the security standard for ISO. So keep going here. So as we'll talk about that, we'll talk about the necessary elements of a privacy program. A lot of this is what I've learned doing privacy assessments at companies of every size, from the smallest to some of the really almost very biggest. How to perform a privacy assessment, which is really necessary, not only for implementation, but for operation of a privacy program. We'll talk about scope. How do you scope a privacy program? Not only in terms of what parts of processes and technology and people, but also what sort of things should you be looking at? What sort of policies and procedures? What sort of operational aspects of your organization should be in scope for a privacy program? We'll talk about that. We'll talk about key issues for a privacy program, and these are things that largely are sort of pitfalls or things that people tend to get tripped up on, and can actually cause a really big delay or challenges for implementing a privacy program. And so I'll kind of walk through some of those and some of the things you can use to avoid those issues. Privacy team, who's on it? Who needs to be involved? A critical element, again, of a privacy program. And then we'll talk about ISO 27701, again, not to be confused with 27001. And that is the PIMS, or the Privacy Information Management System from ISO/IEC. And that, I'll have a little overview of it, what it is, how it's related to 27001. And then we'll talk about the phases of implementation, from preparation, implementation, and then operation and maintenance. If we have time, I will talk about privacy management tools a little bit, because those can really jumpstart a privacy program and help save you a lot of time and a lot of hours, especially for the people that will be helping you implement. And if we really have time, and I talk really fast, we might get to the California Consumer Privacy Act, which is not the focus of this, but it's a good case study. And it's helpful at least to talk about what personal information is in the context of that, what the rights are, which kind of highlights, for example, why you might need a tool, but is also really great for just making sure everyone's on the same page that any user level data is personal information. And so we've got lots of examples there that we might go through real quick. But if not, you can download the deck and kind of go through that on your own time. And then hopefully we'll do a Q&A and have some great questions from you. Look forward to hearing your questions. So please do shoot those over to Mike. Right. Necessary elements of a privacy program. You cannot really even begin to implement a privacy program without understanding the current state of personal information use cases in each system. And when I say that, I mean, what is every single thing that you're doing with personal information, from how are you collecting it, who are you collecting it from, and the whole life cycle of that personal information until it's permanently destroyed and no one has it anywhere, including people you gave it to. That is a very difficult and time-consuming process. And in my experience, it requires questions, and some of those can be in the form of a questionnaire, which we use often. I have several of those, but ultimately interviews and talking to people, looking at the websites, looking at the applications, what are they actually doing, looking at the databases, what's being stored, what are the fields, looking at ERDs, looking at schemas, looking at data dictionaries, and finding all the things that people forgot to tell you about, which is going to be more than half probably of the personal information use cases that you're going to have. Mapping. So when you talk to one group or one team or one application and they say, what are you doing with it? Where do you send it? That can reveal a lot as well. So this whole process of understanding what and the justification, why are we doing this? Is there a reason? Can we stop doing it? Are we required to do it? Is there some statute that says you have to collect and retain this information? You have to understand all of that, because all of those things are going to, when you then look through the lens of the regulation or your goals, you're going to see, okay, this is what we have to do. This information is subject to deletion or it's not. This information is technically considered a sale and people have to be able to opt out of it, or maybe they don't have that right. So you have to understand in detail all of that information. Obviously, people, processes, and technologies, including SaaS applications, cloud applications. The type of personal information, at a minimum at the category level, if not the field level. So you need to, for example, for CCPA, be able to tell people what categories of personal information you've collected, and to some extent, some of the things you're doing with it at that category level. So you have to be not just saying, are you collecting personal information, but what kind? Is it health information? Is it social security numbers? Is it biometric information? Is it just names and emails? You have to know all of that, and you have to know where it goes. You have to know what third parties it's being sent to. We talked about some of these things. And ultimately, you'll have to understand what requirements apply based on those use cases. You'll have to understand what's in place now or what capabilities exist, and then build a roadmap for getting to compliance and implementing appropriate risk-based remediation for each use case. And how you do that, well, that's one of the things you can use ISO27701. We'll talk about that. Once you've done it, you need to ensure that you can prove you did it, because we're talking about regulatory compliance. And we're also talking about, if you say, we don't do this, or we do this, or we implement reasonable security, or we give you the right to access all your data, and here's all of it. If you're making those representations to consumers, or data subjects, or people, not only are you subject to something like the CCPA or HIPAA potentially, but you're also subject to FTC. If you make misrepresentations to consumers, they can and will levy huge fines against you. I'm talking hundreds of millions of dollars. So if they come and say, hey, you said you have reasonable security, you said you do this, you said you do this, you better be able to prove that with documentation. And so that's number two. Anything that you're doing, anything that you're remediating, you better be able to prove you did it and ensure there's adequate documentation of it. Part of that is testing. And so if you have a system for people to be able to make requests, and you are giving them a copy of their information. Test that system, test it before it goes live, keep testing it. There's a famous case, it's a little old now, of Amazon was giving people copies of their Alexa recordings. Of course, Alexa records all the, well, it's listening all the time, and it actually saves to the cloud when you say the magic words. And whatever it hears, you can get a copy of. And somebody made a request for that information for those recordings, and they got somebody else's recordings. And so that, of course, is bad, and you want to be testing and make sure things like that aren't happening, that the system's working the way it's supposed to, it's giving information the way it's supposed to give and what it's supposed to give, and not something else. And any time that you have any significant change, and that includes a change to basically any of those things in the sub bullets for number 1, people, processes, locations, technology, types of PI, data subjects involved, recipients of PI, including third parties, if any of that changes, you need to go and redo the assessment. Even if the justification changes and nothing else changes, you still need to go back and look, okay, now we don't have a legal requirement, or now we do, or now there's some other reason that we're collecting this information. That can change the applicable requirements and change what you have to be doing at a technical level. So you need to go back and do another assessment. Call it DPI, call it whatever you want. Go back and go through and look at the requirements and what you're doing. Scope. Obviously, you got to follow the data. I kind of said it before. You got to go through and inventory all of those inputs, whether it's on a website or an application or whatever, paper, people collecting things at conferences. I mean, I've seen all sorts of really strange data input mechanisms, CCTV, obviously, you name it, recordings of phone calls, all of that stuff's in scope, right? And you need to map it all the way until it's gone, the whole life cycle. And as part of that, you need to look at everything that's on the screen. You might look at some of this and it's pretty obvious, like personal information collection and sources, data recipients, security, DLP, masking, incident response. Okay, I get all of that. Why do I need to worry about MDM? Why do I need to worry about business KPIs, BCDR? I won't be able to go into every single one of these, but I'll pick one. And if you have questions about some of these, we can talk about it either online or feel free to reach out to me after. And basically, like BCDR, there's a couple things. If you have backups or you don't have backups, and somebody makes a request to opt out, under CCPA, you can't contact them again for 12 months. So you can't reach out to them and ask them to give you more personal information to be sold for 12 months if they've opted out of sale under CCPA. What does that mean? It means you need to retain that record, that identity of that person who submitted that request for at least 12 months, so that you don't inadvertently remarket to them or re-ask them for personal information in order to be sold. So that's a requirement for BCDR. It's not expressly stated in the CCPA, but it's a consequence of the opt-out requirements. Similarly, if somebody requests that their data be deleted and they're entitled to that deletion, and you delete their data, but you don't delete it from a backup, and then you have some event where you need to restore from your backups, and you inadvertently restore that data that you deleted, that you were supposed to have deleted, you said you deleted, and it was still in the backup, and you didn't have any process to make sure that when you restored from that backup, you didn't reintroduce that data into your system. Now you've just, again, violated the regulation. So all of these things, even if they're not obvious, there's going to be some personal information privacy requirement scope for each of these areas. So follow that through. Some other key issues. We talked about a little bit about deletion, right? BCDR, opt out, no contact, downstream impact and replication. So sometimes if you delete data upon a request, you might find that that breaks your application or has some downstream impact that was unintended. Kind of goes back to testing again, right? But you also just need to map that out and make sure. Most of the time, most of my clients, what I recommend is where possible that they don't delete all the personal information, the whole record, but they anonymize it by removing any unique identifiers. So if you get rid of things that are unique, that's email addresses, phone numbers, things like that. All the other information that are kind of like yes, no fields, or what store does this person like to shop at, all this other stuff, That's not personal information anymore if it can't be used to uniquely identify somebody. It's anonymized or pseudonymized GDPR. So that is one way to deal with the issue without necessarily breaking everything. You can just kind of randomize the values for those unique identifier fields and leave everything else intact. And that might allow you to keep some business information type functionality intact. The other thing here, hard soft deletion. So soft deletion, and these terms have some variable meanings, but basically if you don't really delete the information, but you delete the reference to it and it still kind of exists and it could be reconstructed, it's not deleted. And that's not going to be sufficient, especially if you have some kind of an incident, somebody does reconstruct that data and you have a breach. So nobody's going to say, oh, soft deletion was good enough. No, you got to hard delete it, or you got to some other way address that risk. Security breach notification framework. So you want to implement a framework. If you're implementing 27701, the security framework is pretty clearly going to be 27001, and that's fine. There's been some statement by the former Attorney General for CCPA, former Attorney General of California, now Vice President Kamala Harris, that you could implement a CIS top 20. Frankly, I think at a technical level, it might actually be easier, depending on which tier you're looking at, to implement ISO. From a GRC perspective, it's a lot more work, but you have to look at that and figure out what framework, again, so you can prove that you're in compliance. Encryption is a safe harbor for most privacy regulation. If it's encrypted and you don't lose the key and it goes out there, then potentially it's not a breach. And considering some of the almost catastrophic penalties, including private right of action for breaches, you really want to make sure, especially for sensitive information or information subject to the private right of action for breach, that you have it encrypted and that you have a good key management system and everything so that you can be assured that you didn't lose unencrypted personal information. And again, testing. Website changes. I think everyone's probably pretty familiar with what's required there now, but anytime you have a change, you're gonna need to update that. Household information can be really tricky. I could spend a whole session talking about that. I won't on this one, but just realize if you have household information, how are you going to address things like somebody wants a copy of it, but it's not really their information, it's about the household, and it could be sensitive information, and you're going to have to identify those issues and address them. There are some times where you may want to conduct the assessment or the initial program initialization. Attorney-client privilege as confidential information. And you may do that because there's been some sort of incident, or there's some other regulatory investigation, or there's some other reason that you don't want that to be discoverable. And so that's just something to consider at the outset of especially the assessment phase of the implementation. Minors, so depending on the regulation, there's going to be different categories. CCPA, it's under 13 and under 16. You probably just don't want to collect information, certainly for people under 13 if you can avoid it. And under 16, probably the same, although it's a little better. There are things like if you're selling that information, it's going to be really difficult. You're going to have to get opt-in. You're going to have to do verification, probably of who their parent is. And that is a tricky proposition at best. So that's a kind of a big issue to watch out for. Discrimination, financial incentive, if there's some financial impact to people, if they don't provide their financial information, or sorry, their personal information, or if they do, there are different requirements you'll have to address there. So if you're turning people away if they don't provide it, or if providing it, if they opt out of that, if they have to pay an extra fee or something like that, or if they get a discount if they do provide it, etc., you'll have to address those issues per the regulation. Best practices, even if there's no requirement for you yet, there are things you may want to do. Perfect example of that, CCPA, there's no right to rectification. That is, you can tell people what their data is, but if it's wrong, you don't have to correct it. You may want to correct it, both as a sort of customer service feature, but also because CPRA is going to require that soon anyway, or some other regulation will. GDPR already does. And that kind of goes to the same thing, customer data, subject experience, and expectations, which is kind of related to national and local implementation. So you could say, hey, if you're not in California, you don't have any of these rights. Sorry, you can't get a copy of your information. If you've already built that process, you probably want to let those people have those rights, but that's a decision you have to make, just keeping in mind that there may be some people that are upset if they don't get rights that people in California have. And eventually they may have those rights anyway as additional states roll out privacy laws, and it's happening. We already have our second state, and I'm sure there'll be more very soon, if not a federal law. Transparency, kind of the fundamental the cornerstone of all of these privacy regulations is being transparent about what you're collecting from people and what you're doing with it. And again, if you aren't transparent, you may run into FTC and other regulatory issues as well. And lastly, verification, authentication. You want to make sure if people are requesting information, especially sensitive information, you're verifying that request before you provide it. If you can't verify it, then you're either not providing it or you're going on some outside the happy path process to figure out what's going on there. I would say err on the side of verifying rather than providing, and most of the regulations allow for that. Your privacy team, I would say the most important thing on here is the left side. So you need to have executive sponsor supported involvement, some sort of authority behind the project, whether it's a charter or something else, because you're going to be asking people, and just like we're all familiar with from security, but privacy is almost even harder. You're going to be asking people that have day jobs to kind of go and take time out of their schedule to help you implement a project that doesn't affect the bottom line or maybe their performance results, et cetera. And you need support to do that from the top levels, or you're going to just run into people ignoring you probably, unless you can establish a good rapport and get around that. But it's always going to be easier with support. Stakeholder involvement. For security work, you wouldn't worry too much about marketing, maybe not legal either, and the business would have involvement, but it might be minimal. For privacy, all those teams need to be 100% involved. And the reason is, again, we talked about the business justification and the business goals. What are we trying to do with this information? Why? How long do we need to keep it? The business has to answer those questions, or whatever the equivalent is. Marketing is going to be heavily involved. They basically are the business with respect to PI. And of course, you always need IT, InfoSec, HR has to answer questions about training and other security related questions. And legal needs to be involved more than they probably usually are, because there's going to be legal interpretations. Is this use case a sale or not? They may need to get outside of counsel opinion, but you want to have them kind of keyed in early and often. And you're going to need a primary POC. I mean, this is good practice for any kind of project, but personal information just proliferates everywhere throughout organizations. There's nowhere it doesn't go. You're just going to be looking at so many different things that if you don't have good organization, good project management, good points of contact, the thing's going to fall apart and take forever, because the use cases are changing so frequently that you will find that by the time you get to the end, you have to start all over again. And maybe that's okay if that happens within 1 year or something, but if you're not even getting halfway through before everything's out of date, then your project's not going to be a success. The actual assessment implementation team, they have to know the applicable regulation and the frameworks cold. And these things, I mean, CCPA was famously written like overnight on a Thursday night because they were trying to prevent a ballot initiative from moving forward, and they needed to get it done right then. And there've been some fix-it bills over the years, but it's still a mess. It's hard to understand. It's hard to read. There's a lot more out there about it now than there was, but realize there's more regulations coming all the time. And whoever is going to be at least the sort of privacy SME as part of that team they have to be up on all of that, up on what the Attorney General regulations are saying, how they're changing, what other state laws are saying, what the court cases are saying. This could be someone from the legal team, it could be a consultant, whatever it is, but someone really has to understand what the privacy rules are, what the requirements are, and how they apply. Hopefully they have some previous assessment experience, ideally privacy assessment, but you at least need like a CISA or something in there who can understand use cases. In my experience, you have to understand the business, and there's so many different businesses even within one organization, and I use that term really broadly. I mean, there's so many different operations of an organization, and you have to understand what they're trying to do, because they won't always clearly tell you. And so someone who's familiar with working with people and kind of getting that information out is really critical. And they have to have the bandwidth. If this is, again, personal information is going to go everywhere. The devil's in the details here. Someone's going to need to be very committed and methodical to get through all of this before everything that they've done becomes kind of out of date and obsolete. So it's important to have that bandwidth. And then impartiality, third-party objectivity. Someone who's too close to this stuff is true for security too, but I think even more so for privacy. You have to sort of take a step back and say, hey, I know we use social security numbers as passwords, but is that really a good idea? You'd be surprised that people just kind of see something all the time and they don't think about the necessity of it or the risk of it. So it's helpful to have objectivity. All right, so PIMS. That is ISO IEC 27701, Privacy Information Management System. It is an extension, as I've mentioned a couple times, to ISO 27001. It's for privacy management. It extends those guidelines, including the reference controls in 27002, with considerations for the protection of privacy. And so hopefully ISO doesn't get mad, but I just took this quote directly out of the 27701 standard because I thought it was really funny. And it's kind of, in a nutshell, what that whole standard is, although there's some great additional guidance. But fundamentally what they're saying is, in practice, where information security is used, use information security and privacy instead. And so if you have a policy and procedure that talks about information security, 90% of the time you could just add the words "and privacy," and you'll pretty much be, from a policy perspective, where you need to be. Of course, from a procedure and technical perspective, there's probably a lot more work, but that's the basic idea. It's the same structure as ISO 27001. If you're familiar with that, you know what PIMS is already. And you just need to go through the additional guidance and apply it, and you can update your ISMS to incorporate PIMS, and you'll be well on your way. And we'll talk about what that looks like in a minute. And again, just like 27001, you'll need to do a preparation, implementation, and then operation and maintenance phase. So what does that look like? Well, all of these things that are the same things you'll need basically for 27001. That is an ISMS, and now adding PIMS to that. A risk assessment methodology, again, adding privacy to that. And a risk treatment plan. So again, if you already have all of these things, you'll just need to redo them with privacy, or just do a privacy risk assessment, which is kind of the program I talked about earlier, and come up with a treatment plan and a statement of applicability. Just like with 27001, they're going to give you an appendix with a bunch of controls. And you can, now, there's a couple of really key differences. For example, you need to determine, and this is kind of something you do for 27001, you talk about your interested parties, your stakeholders. You need to determine who your stakeholders, your interested parties are, and that's going to tell you whether you're a processor or a controller. CCPA, that's what the ISO uses. It's GDPR terminology. If you're following CCPA, it'd be a business or a service provider, but it's the same thing. And you basically have to figure out, hey, is this my information? That is information that I decide how it's processed and what's done with it. Or is this someone else's information that I'm processing on their behalf and I'm just a processor and there's some other controller out there that I essentially report to? That's part of the process, but you have to make that decision. And those reference controls are going to be different. There's actually an A set and a B set, depending on whether you're a controller or a processor. And I've run into many circumstances where a single organization is a controller, a joint controller, a processor, a sub-processor, or some combination of all of those, depending on the use case and the context of the personal information and what's being done with it. They may be collecting information from a consumer, and in the same form that a consumer is filling out, there's some information that is for a profile that organization is building and they're the controller for it. And there's some that's an iframe that's going straight to some third party and they're barely even a processor for it. And so you have to address all of those issues, identify them, and identify the appropriate controls for each scenario. And all of that's going to happen in this basically set of activities. So what does that look like for documentation, your ISMS, now your PIMS? Kind of like what I have there, information privacy policy and objectives. There's an asterisk and you'll see, well, that includes figuring out what your interested parties are. If you have personal information, if you're using the PIMS, for sure, there's going to be consumers or data subjects somewhere. Even if you're not interacting with them directly, there's going to be supervisory authorities, that's your regulatory authorities. There's going to be either other PI controllers or other PI processors and their sub-processors or subcontractors, or maybe they're not. Maybe you're just the controller and you don't have any sub-processors or joint controllers. That's okay too, but you need to figure all that out. And that's kind of going to lead to your scope. Of course, you're going to need an inventory of assets, including information assets. Be really clear about that. We're not just talking about hardware and cloud assets and things. We're talking about, databases and fields and sets of information. And then you go through your risk assessment again and figure out what controls you need to implement and where, and how you're going to implement them. And that should lead you to a set of policies and standards. Your access control policy, acceptable use AUPs, privacy roles and responsibilities, supplier privacy policies and how you determine compliance, incident management, incident response, that's huge. Business continuity, we talked about why. All of the statutory, regulatory, and contractual requirements, you need to document that and map to that with your policies and procedures. Your records of training, including privacy training, which is required. And then stage 2 here, where we have that's if you're actually going for your ISO27701 certification. Just like with 27001, you're going to have your stage 2 certification where you actually have to show evidence that these controls have been in place. But again, like we talked about, you should be doing that anyway, so that whether the audit comes from someone you've paid to do it for your certification, or it comes from a regulatory authority, or it comes through discovery and litigation, you're prepared with evidence of compliance and of an effective program. All of which kind of should have ultimately be documented in your ISMS, aka your PIMS, which is separate from these policies and procedures. And that's a whole other document that we can probably talk about offline if you're interested. Risk assessment methodology and process. I mean, obviously, this is the heart of the program. You need, if you're following 27001 or 27701, you need to have a really solid risk assessment methodology and risk assessment process. I'm a little biased because I get paid to do these, but I highly recommend you outsource this to someone that knows what they're doing, whether it's the Big Four or an independent consultant, or you have someone on your team that has experience with this who's maybe got a lead implementer or auditor certification for ISO, but it's not something that is easy to just pick up and do. It's very GRC intensive, it's very specific, and I recommend that you select and interface with your auditor right away, so that you understand kind of their way of assessing these things. Some of these auditors have a portal. You can go in and see what they're going to be asking. Some might give you their work paper and you can again see what they're going to be asking, but at least get some guidance and feedback. starting early on as you go through this process, because there are some peculiarities of the different auditors out there. If you get a good consultant that's implementing this, if they have a partnership with an auditor, or that's not the right word, but an auditor at least they work with, or if they've worked with all of them a lot, like most of us have, they kind of know what those peculiarities are and they can guide you through that. Risk treatment plan, again, you're going to have to cross map to your Annex AB controls, depending on whether you are a controller or processor or both. And you're also going to want to map to your regulatory requirements that are applicable, whether it's CCPA, HIPAA, GDPR, etc. So you can quickly identify how you're meeting those requirements, or whether they're applicable or not, and why, and then what that evidence is and the policy and procedures related to that. And that'll take part in your statement of applicability. You'll document all of that. Another thing you might want to map to is ISO27701, which is technically the privacy framework for ISO. It looks a lot like one of these other privacy regulations like GDPR. It's not, I think, widely adopted right now, because most people that are running 27701 right now are doing it because they're trying to comply with GDPR or one of the other privacy regulations, and so that's kind of redundant. But you should be mapping to something, whether it's the regulations that are applicable or a framework like 29100, where you could use NIST Cyber Privacy Framework, something like that. Implementing the risk treatment plan, I mean, that kind of goes without saying. You're going to have new controls, new procedures, new standards. You should have some kind of audit. We talked about that, I think, to make sure that the controls are in place and effective. Internal audit or through a third party. And I think probably the most important thing on this slide is just, staff, your people can't implement any new controls without awareness of why they're necessary and training on how to implement them and perform as necessary. I mean, and it should go without saying, but I'll just say it because I see it all the time where it doesn't happen. Give them access to the controls and make sure that they have reviewed them and know how to get to them. Publishing a set of policies, procedures, standards that no one ever looks at until the auditor comes in and the auditor asks about it, and the person isn't familiar with it or even doesn't even know where to find it, will cause you to not get your certification, and really will cause your whole program to be a waste of time. So definitely do the training and awareness. If you are going for certification, we talked about this a little bit. You'll do your stage 1, which you're familiar with if you've done 27001, but basically you show that your processes and policies and documentation is in line with PIMS and 27701. And it's good because that makes sure that your your plan at least is right. And then you can operate and monitor it and do your review and make sure if you need changes that you implement those and document it. And then you can do your stage 2, your certification audit, and actually show that your program is in place and effective. It's just like if you've done SOC 2, your type 1, your type 2. It's very, very similar. All right, so hopefully I wasn't speaking too fast, but I wanted to give us some time to talk about tools and a little bit about CCPA. So tool capabilities. So tools, first of all, a good tool can really give you a big speed boost to your program and help your program be much more effective and thorough than it would otherwise be. But a tool that's not a good fit can do the opposite of that. And I think we've probably all seen that, where there's some tools that require a whole team of special, dedicated, highly paid people to implement, and it seems like half the time that implementation actually isn't successful, and we just wasted a lot of money and time and didn't actually improve anything. So it's really important, I think, to find a tool that's a good fit for your needs, for your organizational size and complexity and maturity, for your budget, obviously. And ultimately what you want that tool to be able to do, and I put this all the way at the bottom, it should be at the bottom and the top, automate, so that it's saving humans from having to do things that a tool can do. But again, you need to be careful that you're not automating in such a way that you create an incident by either having someone's data go to the wrong person, or that you actually have a non-functional system that isn't actually giving people anything, or any combination of those things. What can a tool do? Well, the biggest things fundamentally you'll find when you start doing your assessment is that you don't exactly know where all the personal information is. It replicates itself everywhere. It's stored all sorts of different places, in structured and unstructured, and Google Drives and box folders and shared drives and filing cabinets in some organizations, and every other place that you could store information, you'll find personal information is there in some form usually. And so a tool that can help you find that is helpful. It's also helpful in the sense of finding all the instances of it, usually searching with unique identifiers. So again, if you have a request for deletion, you might collect the data and store it somewhere, and then you delete it there. That's good. But if you've copied that data to a bunch of other places, and it could be anywhere from some kind of data lake or log files or who knows what, people's Excel file on their email, they downloaded it on their laptop, they can get all over the place. You're not complying with that deletion requirement because you still kept the 18 other copies of that data that you were supposed to delete, that you said you deleted. And if then there's a breach of that information, that laptop gets lost, what log files get stolen, whatever, now you have a breach of personal information that you told somebody deleted. It's really bad. So a tool can help address that. It can help you map that data flow, where it's flowing between systems, between applications, potentially also between geopolitical boundaries, which can be really important, especially with things like GDPR, with the collapse of Privacy Shield, other things you might really need to know if you have information that's moving from the EU to somewhere out of the EU, or from somewhere outside the EU into the EU. And so it's helpful if you can see that. Automated authentication verification, it's really great if you have an email that you know was given to you by the person that provided that personal information, and then you can just send them something that says, hey, did you make this request? They can click it, and now they're verified, and then maybe you can automatically give them their data. Well, you just solved, half the problems for privacy rights requests right there. A lot of tools out there can do that. A lot of them do it, but require a lot of manual input. And so you want to make sure that the tool, again, has automation as part of that process. And ideally, facilitates the consumer data access request handling, gives you aging, tell you how old are these things, is it getting to the point? All of the privacy regulations have a deadline that you have to comply with the request, or at least get some kind of extension and tell them what's going on. So you want to know how old the request is, if there's some manual input required, if it's getting close up to that 30 days or 45 days or whatever it is. Single pane of glass, both for you and potentially for the consumer, so that you can see, again, their information may be spread across many different systems, databases, and other information stores. And if that program, that tool, can grab all of that, present it to you in a single pane of glass, that can be helpful for rights request fulfillment. It can also be helpful just for the assessment process. So when you're talking to people, you see that and you say, well, last time we talked about these three kinds of information, but looking at this, well, there's checking account numbers and social security numbers in here. Oh, we're doing check verification and fraud prevention, so we have that too. Okay, well, that's good to know. We need to take precautions for that, So tool can help you with assessment and compliance as well. You obviously don't want to just insecurely communicate personal information, especially if it's sensitive. Almost all these tools can facilitate some kind of HTTPS, TLS transmission of the data securely after they've done the authentication. A lot of them can fulfill other requests, other compliance things like cookies, do not sell, opt out, restrict processing. Most of these privacy tools have that functionality now. And they can actually look and tell you. Usually they can look at your website and say, here's the cookies that you've got there. And here's the ones that look like they're required, and they can tell you what the flags are, and they can basically give you a cookie analysis, which you'll need if you have a website that's doing that kind of cookie work. And you can use that to track compliance. So this can be where you keep your repository of sort of evidence that you're doing these assessments, that how you're implementing the requirements, etc., for each application, as well as for each request. If a request came in, you fulfilled it, you'll have a record of that on one of these tools. That can be really helpful. If someone claims that you didn't fulfill their request, you can show that you did. You can also use these tools for consent or disclosure. If you have to have usually one of those two things or some other legal basis before you actually even collect any information, or at the time you're collecting the information. And so whether it's a click through or some other form that they've checked a box on, et cetera, you can track that and associate it with that individual and their personal information record in the tool. Facilitate DPIs, again, that's just the assessments. We talked about that. You can also use it to assess and track third-party compliance and risk. A lot of them have sort of built-in functionality for that, or even like, to the extent that third parties get assessed all the time, they might have a lot of that information sort of pre-populated for you, which can save you a lot of time. Another thing that's not on here is connectors to third-party applications. If you've got stuff in Snowflake or whatever else is out there, Salesforce, they have connectors that can go in and find that data, identify the use cases, and again, just automation wherever possible. Biggest consideration for tool selection is going to be that it's a good fit, but you do also need to have a process for doing it. Centralization is down that list, but what tools do you have already? What tools other teams are using? There can be a tendency to do this in a silo, which is the worst thing you can do, and a bunch of people are buying a bunch of different tools that don't play well together. You may have some tools already that have modules that can do some of these things, like ServiceNow or Informatica, Big ID. If you're already using those platforms, you may want to consider adding the functionality to do some of the privacy work, especially if you have like SMEs that already know how to use those tools. And on the other side, if there's a tool like if you're trying to do Informatica and nobody knows anything about Informatica, that might not be the best tool because the implementation, integration cost and time could be high. If the tool doesn't integrate, if all your data is stored in files and other flat files and things, and your tool isn't able to parse those files, and that's probably not a good tool. Existing compatibility covers it. So CCPA, we got a few minutes. We can cover that. CCPA is kind of critical for us here in the US because it is the first real kind of universally applicable, no, it's not quite that, privacy regulation. It doesn't apply to HIPAA data, but then you're already covered by HIPAA. And most GLBA kind of similar, but for most businesses that are dealing with a significant amount of personal information or they're big enough, the CCPA probably applies, unless they're very, very local in a state, like a state insurance or something like that. And the reality is, what we saw, if you were following with the breach notification laws, we had one in California, then we had a few other states. And next thing you know, now we have all 50 states plus a growing number of municipalities that all have breach notification laws. There's really no reason not to expect that the same thing is going to happen with privacy laws. I think a lot of people thought it was going to happen sooner, but like I kind of alluded to before, the law was not the best written law, and it had a lot of problems. And I think a lot of other state legislatures saw that and saw that the bugs were still being worked out and kind of held off. But I think that period is coming to an end, and I think we're going to see a lot more laws. I think they're going to look more like the CPRA or GDPR and have even more requirements than CCPA rather than less. The time will tell, but that seems to be the direction we're headed in. So if you're not familiar with the CCPA, we'll talk about it a little bit, but I definitely recommend that you look into it and familiarize yourself with it if you aren't already. This overview, definitely not intended to be a real guide to the CCPA, but just realize that, like we've talked about, and I'll show you in a second, there's a hugely broad definition of personal information. It's almost anything. Once you uniquely identify somebody, anything about that person is personal information, from what their preferences are, what brand of potato chips they like, where they were, what they did they click on something or not click on something, all of that. Their IP address, which I question the personal nature of that, but is specifically defined in the statute as PI, IP addresses. And consumer. Well, consumer sounds like, hey, maybe that's someone who bought some stuff from me. Nope, it's any California resident. I don't know why they called it a consumer. That's what they did, but it's all California residents. And that can be people that aren't even in California and haven't been for a while, like college students, military, people traveling, et cetera. So one of the things we deal with a lot is, how do I know if this person's a California resident? You pretty much have to ask them and take their word for it. Geo tables and IP, trying to figure out where they're coming from with VPNs and everything else. I think that's a bad idea to rely on that, but you'll make that decision and make sure you understand the risk. But just realize it's everybody that is a California resident that it applies to. They get all sorts of new rights. I think we talked about most of them. They have sale. The definition keeps changing with new legislation and attorney general regulation. There's privacy notice requirements. You pretty much have to tell them what you're doing. Talked about the law being in flux. And then probably the more relevant things, enforcement. What are the penalties? Well, they could be potentially pretty huge. We're still in early days, so we don't actually know. There's going to be a new agency, the California Privacy Protection Agency, that takes over in 2023. That's part of the CPRA. But we could see up to $7,500 per violation, and that could mean that each time that you don't fulfill someone's privacy rights, which could be just not giving them a proper privacy policy when they visit your website, you could end up with a $7,500 per violation regulatory fine, which could add up obviously pretty quickly. And the private right of action, if you have a breach, is almost worse, because you're not dealing with a regulatory authority that's hopefully not trying to put you out of business or cares about keeping you in business and wants to take a balanced approach. You're dealing with a trial bar that would get as much as they can possibly get, whether they have to get it from you out of a liquidation sale or whatever. And it's an increasing amount of information that's being subject to this private right of action. So, and that's $750 per consumer. And it doesn't matter, they don't have to prove any damages. It's a statutory damages. They just have to prove that you didn't have reasonable security and that there was a breach. So potentially astronomical. If you figure 1 million consumers, $750 million each, that's $750 million, nearly $1 billion just for 1 million consumers. And a lot of organizations have tens or hundreds of millions of consumer records. So it's a little bit frightening. And then you look at what are all those things? And the things in the orange boxes here are potentially subject to the private right of action, either now or with CPRA. And there's a lot there. And these are just examples, right? So something to be aware of. And here's some of the rights that they have. And again, not intended to be a full description of CCPA. I could give another whole talk on that, but definitely familiarize yourself with it and who it applies to and what it requires. And with that, I will open it up for questions and answers.